Our first matter is in the matter of HRVC Limited Partnership. This is case number 0543-2023, so the 2023 term. In terms of argument time, we understand that the appellant has reserved 3 minutes for rebuttal, and then for appellees, Howard County or Howard Zoning will have 10, Hickory Ridge will have 10, and then Mr. Hurwitz will have 5 minutes. And so whenever anybody's ready, Mr. O, whenever you're ready.
May it please the court.
Yes, sir.
Good morning.
Good morning.
My name is Sang-O. I am counsel to HRVC LLC Kimco Realty, who is the appellant and petitioner in this floating zone case. The appellant is the owner of a Hickory Ridge Village Center in Columbia. It's a 96,000 grocery anchored shopping center built in 1993. My client presented a plan to remake the center as a mixed-use development, including a 4-story mixed-use building with apartments and retail. It is this building that is at issue in this case. The proposal for apartments was allowed by the Howard County Council's passage of a Council Bill 29 in 2009, which allowed residential uses to be added to the village centers of Columbia to help revitalize these aging centers. Columbia has 10 villages, each with its own commercial village centers. Many businesses struggle in these centers because the housing around the centers is not enough to sustain the businesses. In 2015, Kimco initiated the process, and after more than 25 meetings between the developer and the neighborhood residents, some neighbors support the project. Others were opposed, including Deb Young, first an ordinary citizen who volunteered and participated in the creation of the Village Center Community Plan and the Community Response Statement, which we'll continue to discuss. Later, as the case continued through the process, Ms. Young also provided public testimony before the Howard County Planning Board, asking them to deny the project. By that time, Ms. Young was a candidate for the Howard County Council, a seat that she ultimately won in 2018. The same development proposal that was before the Planning Board is the proposal that went before the Zoning Board. Ms. Young, who was then a council member, sat as a member of the Zoning Board, declined to recuse herself. She participated in the case, or as we probably like to characterize it, over-participated in the case. Ms. Young was also later discovered to have ex parte communications with party opponents in this case, some of which she destroyed, even after being aware of the policy that she could not destroy those messages. After almost 2 years of hearings and aided by Ms. Young's participation, the board voted 3-2 against the petitioner's proposal and provided a 12-page decision of denial. The two questions in this case is, first, was Ms. Young required to recuse in this case? The opposition asserts that the standard for judging whether Ms. Young was obligated to recuse in this case is whether she had an unalterably closed mind on matters critical to the disposition of the proceeding. This is incorrect. The unalterably closed mind standard is for legislative or quasi-legislative matters. The cases cited by the opposition, the Fogel case, and in particular the Turf Valley Associates case, are quasi-legislative cases. In Fogel, the issue was a COMAR regulation, and in the Turf Valley Associates case, the issue was a zoning regulation amendment to delete what's known as a planned community district at that time. In 1971, the Turf Valley case, Howard County was still a commissioner form of government, and this is in the case. There are 2 elected officials who campaigned at that time while the county was transitioning to a charter form of government, and they made campaign promises, one of which was to say that they were going to delete via zoning regulation amendment. After they won, then council member Miller asked that his zoning regulation be acted upon. The zoning board at that time, acting quasi-legislatively, approved the deletion of that provision in the code. Consequently, it really wasn't until 1994, and I believe this is the brief that Mr. Hurwitz referenced, when the county experienced a referendum.
For Turf Valley, where in the case does it say that the standard of review that is discussed in this case is limited only to what you're calling legislative actions?
Well, Well, the principles enunciated in Turf Valley clearly speak, first of all, the subject is the zoning regulation amendment, which is a regulation and a legal provision. Today, Your Honor, zoning regulation amendments are passed legislatively. And I would submit to the court that legislation has to be submitted, or has to be passed legislatively. It can then be done quasi-legislatively, and that's what happened in Turf Valley. The difference between this is that in certain quasi-legislative matters, or in pure legislative matters, it requires a signature also of the executive branch, the county executive. So when a matter goes before the zoning board, they are required in this kind of case. I think the better case, frankly, is the Kenwood Gardens condominium case. I think it's absolutely clear that in a quasi-judicial case, and that's what this is, it's a floating zone case, all of the requirements, determinations that are made are purely adjudicatory. There is no policy decision made, nothing about the wisdom of the law. That's not the purpose of an administrative board. In this case, I believe if you look at the Turf Valley Associates case and understand that they were performing a quasi-legislative action, it cannot serve as precedent for this case. That would be a fiat for every administrative body in this state, every zoning board, planning board, to essentially exercise quasi-legislative powers, and they're not allowed to do that. I think Mr. Hurwitz points out that if you exercise legislative powers, there is the right of referendum. That there's not a right of appeal, but instead the remedy is that citizens get together, put signatures together, and put it on the voting ballot. That's not this case. This is a purely floating zone case. Floating zone cases, Your Honor, in the nature of special exceptions, if you've ever heard that. Special exceptions, or conditional uses as they call them, another floating zone type case, granted, denied all over the state of Maryland every day. None of those require quasi-legislative actions. They're all done by hearing examiners, Board of Appeals. They are purely administrative matters. That's what this case is. If you look at the criteria, there's not one policy decision made. The policy decision was made in 2009, albeit it was a prior council. This council simply didn't like the law. If you look at the transcript at 11:10, you'll hear some of these statements. Mr. Youngman, who talked about and said he wouldn't have voted for the law. It was his statement. That is an improper statement within the context of an administrative case. It doesn't matter whether you voted for the law. Mr. Youngman, one of the council members who voted against this, lost himself. He believed in his mind that he was there as a county council member sitting as a zoning board and could take certain liberties.
Do you really think that saying that you wouldn't have voted for the law is the same thing, is akin to saying you wouldn't enforce the law?
Well, I would say, Your Honor, that for an administrative board member, the statement that they do not agree with the law, there's no reason for it. There's no purpose that is probative of any issue in the case.
But it just might be superlative.
It could be. It could be.
I don't agree with this.
Well, I can certainly understand and express.
One or two trial judges say that.
Well, I want to add to that, Your Honor, and I want to add to it by talking about Ms. Young's statement. Remember, one of the issues in this case was talking about the board member's perception that the criteria was subjective. Mr. Youngman made a statement saying that, I mean, it's great that you're looking at this term overwhelm as objectively, but I think it's okay to look at it subjectively too. That's why we have a zoning where there's like 5 human beings just going through and checking boxes as if everyone interprets overwhelm the same. That's precisely the point. They have to. They can't be 5 members that decide, I have a different impression of what the law is. That, a dissenting opinion, Christiana Rigby verified, quote, the zoning board members learned through the hearing that there are seemingly endless ways to perceive something as overwhelming. Ultimately, this subjective term will continue to be interpreted in a subjective manner. Ms. Young, at the extract on 99, exclaims that the criteria seems pretty subjective to her. Ms. Walsh, another council member, claimed that the proposal in extract 100, that the criteria in this case is subjective.
But don't judges all the time, judges or persons that are adjudicating matters, don't they sometimes ask questions to see what the answer is, and not because they have that they in fact feel that way, or they are locked into that particular thought?
Well, certainly, Your Honor, but in this case, the comments that were made here were made during deliberations. This is at the end of the case. Well, we would submit
but not deliberations, because you weren't there during deliberations. You're saying that they were done during deliberations?
These statements that they rendered about subjectivity, and I think it's okay to be subjective, they were rendered during their deliberations. This is an odd case. The deliberations were actually captured on recording, and it's in the transcript. These are statements that they made in contemplating the case to believe that subjectivity was...
Even then, you may make statements to see how the other members of the panel feel about a certain thing, and not because that's the way you feel.
I'm simply stating that the board majority, each member expressed their opinion that they believe subjectivity was appropriate in this case, and clearly it is not, Your Honor. We went out at length.
So are you... You started out with the recusal argument. Are you conceding that there's substantial evidence in the record to support the decision?
I'd like to go back to the bias, if I may.
Oh, okay. You started out with the recusal.
No.
Which if you lose on the recusal and there's substantial evidence, then...
I think if we went on either, this case needs to be reversed. First, on the bias issue, and I cite the case of Sharp versus Howard County, where Judge Kane had to recuse at the end because he had performed, I think, writs of covenants 17 years ago. The other side has the task of arguing that the rules, in this case, 102.11, that those rules of judicial conduct, which do apply to admin board members, they have the task of arguing that it was perfectly proper for this administrative board member to, number one, have testified in public about this specific proposal 2 years prior to this. They think it's perfectly proper that she sat in on the very case, that it was perfectly proper for her to raise the exact same questions that she's talked about in her planning board testimony, which I submit to you is on 132, traffic, school overcrowding. It's the same issues that she questioned staff on. That's when we determine something's not right. We need to make a motion to recuse.
If I could stop you on that point for a moment. So my understanding is that her testimony was January 4th of 2018.
That is correct, Your Honor.
And that the first time that there was any question about her partiality raised, which wasn't a motion, it was essentially an inquiry.
It was a question at the very first hearing.
July 24th, 2019.
That's correct, Your Honor.
After she had become elected as a council member in November of 2018. And then the recusal motion was not until September 20th of 2019, after she had cross-examined the witness.
Yes.
So how do we conclude, based on this record, that the recusal issue is even preserved? Why didn't Kimco make the motion really at the time that she was elected to the council in November of 2018?
Well, first of all, Your Honor, the passage of time between the time that she made the statement to the time that she actually convened in the case as a decision maker was approximately 2 years. What people say during the election and the statements that they make, you never know what they're going to act as elected officials.
Isn't that exactly what Rule 18-102.11 gets at? Is that it's, if I have the right rule, the rule from the Code of Judicial Conduct, doesn't it really get at statements that are made in an election about pending matters or things that might be pending?
Your Honor, and I would also add, comment 2 requires an obligation on Ms. Young's part to recuse, irrespective of whether we file a motion. So we did file a motion.
But her failure to say anything about it and disclose, I mean, she could have cured this by disclosing, but that doesn't prevent...
Cured what aspect of disclosure?
Well, cured the fact that she'd made prior statements.
Well,
but that doesn't, I mean, that's not the only route to this. Why didn't somebody, your client, make a motion for her to recuse herself?
Your Honor, there's 5 board members. You need 3 to prevail. We weren't sure exactly where she was, and frankly, we weren't sure at that time. She had indicated on the record, other than that one statement, some type of bias. It wasn't until she asked the same questions about the concerns that she had previously that we became concerned. We made the motion.
So if she seemed favorable to you, would she not have had a conflict?
No, Your Honor, we just didn't know. And at that point in time,
to see if she was favorable to you or favorable to the other side.
Or she could be impartial. The Surratt case, the Jefferson L. case.
Is the only way that she's impartial then, by that analysis?
Your Honor.
She seems to be going in your direction as opposed to in
No,
their
Your Honor.
direction?
In fact, what triggered it for us was that her questions and her concerns were identical to what she testified in the planning board. That for us took away, because the question we asked her in the first hearing was, can you be impartial despite your testimony in the planning board? She said, I have not made up my mind. My mind's open. And it wasn't until the second hearing, the very next hearing, we realized that she...
But if the answers were good answers, then perhaps you would have, she asked questions.
Asked questions. And the concerns...
But she didn't give the answers to the questions.
No, Your Honor. We didn't care about the answers. It was the questions and her believing that these are still issues. This is what the other side is doing, Your Honor.
That based on the question. You might think you know what I think about this issue right now, but you don't.
It doesn't matter. This is a reasonable person standard, just like Your Honors have. The other side would argue that every administrative board member and every judge in this thing could go speak in public about a specific case, find out extrajudicial information about the case, but then actually sit in on the case.
Well, many times, especially with a multi-person board or like this court, I may ask the question, but I'm not really talking to you. I'm just talking to Judge Ripken. So that happens all the time. But if you're going to perceive my view because of the question that I asked is questionable,
Your Honor,
because you're perceiving that the person that's asking the question believes what they're saying to be true and will act upon that, when in actuality the person is either one trying to get a good answer, and if they got an answer that satisfied them, then perhaps they would follow that, or they're really not speaking to you but are speaking to the other four members of the board or
I see that my time
council. That happens all the time. But I believe, because I've done it myself.
I have to convince this court. I believe my time's up, Your Honor.
You may continue your argument.
I believe I do have to convince this court that, objectively speaking, that we had a reasonable apprehension that one of our fact finders was not impartial. Understanding the statement, extrajudicial information, that she participated in the creation of exhibits for the case, the ex parte communications that they never let. This member, objectively speaking, should not have been sitting on this panel. She did. Bias in that regard is reversible error. And as we get to the second, it is an erroneous conclusion of law. This council believed, this zoning board believed, that they had authority beyond an average admin board. They say that it's not the average administrative agency, that they have legislative discretion. And I question what that could possibly be, because that's what puts it into the legislative arena. Thank you, Your Honor.
Thank you. So we'll be hearing first from Mr. Moore, is that correct?
Yes.
Good morning, sir.
Good morning, and may it please the court.
Yes, sir.
David Moore for the Howard County Office of Law on behalf of the Howard County Zoning Board. As the court has observed, there are two issues that it is called upon to decide today. The first is whether my client, the Howard County Zoning Board, had substantial evidence upon which to make the decision that it made. Second is whether it made an error of law in not requiring one particular board member to recuse herself. As to the first matter, there can be little dispute that they had sufficient evidence to reach the conclusion that they did, in part given the posture of this case. Most land development cases, I would guess, come before this court in a posture of an approval of a land development. The developer is then called upon to defend that there was, in fact, evidence to support that each of the relevant criteria for approval of their petition was shown in the record. In this case, where the party who has appealed is in fact the party who bore the burden in front of the Howard County Zoning Board. They had to prove each of those criteria were met. There is no evidence in this record that my client, the Howard County Zoning Board, was persuaded by a preponderance of the evidence that each and every one of the criteria that called for in the Howard County zoning regulations was met. Accordingly, the petition couldn't be granted. My client went beyond that and explained a specific reason that 3 board members determined that they felt, in fact, regardless of the other criteria, that it could not be approved. And that is the concern that the residential uses, which are permissible provided they do not overwhelm, but instead support the other uses at the Village Center, in this case would in fact overwhelm them. As cited in our brief, it is not actually the board member who appellee calls to recuse, Ms. Young, who commented most pointedly on this. It's actually a different council member whose constituents do not reside surrounding the Hickory Ridge Village Center, in fact from a different political party than Ms. Young, Mr. Youngman, who expressed, while comparing it to the Wild Lake Village Center, that appellant complains the board failed to take into account, that he saw a difference between the 2 village centers, that while the residential uses that were approved for the Wild Lake Village Center, he understood that in this case he saw them as different.
Well, they were different buildings, weren't they? Different sizes, different. One was 3 stories, I believe. One was 4 stories, and I suspect that over the 10 villages in Columbia, that they all should be probably are different in terms of the surrounding area, the constituency.
It's the very point, Your Honor. It's the very point of the original development. Each of these is a unique neighborhood, each served by its own special and closely guarded village center. The residents of the surrounding communities regard them as their village centers, and they're very protective of them. They are each tailored to the communities they serve, as they were since Mr. Rouse's company originally began the development of Newtown. In this particular case, while the Wild Lake Village Center addition of residential uses may have been properly suited to that particular approval, in this case, the zoning board members found they just weren't persuaded. In fact, Mr. Youngman's discussion that is in the transcript in this case reflects the fact that he didn't say any residential uses couldn't be permitted. He had concerns about what was proposed, and he was not in a position to himself go in and figure out the right way to alter this to make the proposal work. Because the zoning board can approve without approving exactly what was originally requested. In this particular case, they didn't make a finding that, well, we can't approve your original petition, but if, for example, we had this particular number of apartments, or they were this number of lower stories, or they were located in this particular different area of the village center, that they wouldn't work. Instead, what Mr. Youngman said in the record is that he wasn't in a position to do that. Basically, the petitioner hadn't proven their case. They hadn't given the board what it needed to approve either the original petition or some modified version of that petition. So the zoning board clearly had substantial evidence to reach the conclusion that it did. Its conclusion was that it had to deny this petition because it was not persuaded that the residential uses as proposed would support and enhance but not overwhelm the other uses of the village center. The fact that a different village center with a different proposal that appellant would argue is the same may have been approved does not mean that in every one of the village centers in Columbia from now on, the owner of that village center is now permitted to come in and as of right demand, we get this number of apartments because you gave it to us at Wild Lake, and that means you can't ever tell us it's not the right number.
But it could connect with the arbitrary and capricious argument, correct? If you are consistently allowing another project that has similarities to approving it, and then this one isn't, or sometimes they are and sometimes they aren't, there's at least the argument that that's...
I understand making the argument from that one fact, but it's just one fact. As Judge Wright noted, there are a variety of factors that play into each and every one of these village centers. And in this particular case, the village board, the zoning board, explained why in this particular case, this number of units located in this particular part of the village center with this particular architectural design just didn't work because it would overwhelm the rest of the village center. As I said, Mr. Youngman's comments explained how he saw the difference with Wild Lake. He didn't say he thought Wild Lake was wrong, he said he saw it as different. If you had brought in Wild Lake, presumably you could have gotten that same approval again. They didn't. They brought in Hickory Ridge. Long Reach is even more disparate. Long Reach was a village center owned by the county at that point, seeking a creative redevelopment to reinvigorate it after a finding that it required special help. In fact, that development has yet to be accomplished. That developer hasn't built what they originally got approval for. As your honors can well imagine, while there's this array of criteria for each of these projects, which particular factors are most the subject of testimony in a given project varies depending on the individual project, and the potential for the residential uses in Long Reach to overwhelm the rest wasn't the focus. The focus there was on the amenities, on getting enough things. There was going to be a vertical garden. There was a variety of creative things to reinvigorate the Long Reach Village Center. It's dramatically different than what was proposed at Hickory Ridge.
Can I turn you to the recusal issue for a second? So what is your view on whether what was in front of the zoning board was a legislative proceeding or a quasi-judicial proceeding?
This was a quasi-judicial proceeding. However, nothing that is presented in this record suggests that any board member was required to recuse herself. First, as Your Honor's question elicited, the fact is that the original issue, her prior role as a citizen, was waived when the appellant decided to keep their powder dry and see how things go before they decided to pull that out, to remove a board member who they now decided, maybe we don't want her on this board. They're not allowed to do that.
If they hadn't done that, if they had raised it initially, would there have been a conflict sufficient that she ought to have recused?
No, there wasn't anything to raise anyway, because the fact is that Ms. Young's role as a citizen who testified not actually on the issue that decided this case, she didn't testify on the residential uses overwhelming, she talked mostly about traffic issues, did not demonstrate that she had already reached a crystallized point of view on an adjudicative fact. She hadn't already decided this case. She's permitted to have broad policy views. She's permitted to have even express prior opinions, as judges are, as long as they haven't reached a crystallized point of view on a given fact that they're going to be called upon to decide. She hadn't decided the residential uses here were overwhelming, and in fact, the record of this case reflects her working with them, pushing, trying to see is there some version of this that is approvable.
Would you concede that the Code of Judicial Conduct is the right thing that we should be looking at in terms of assessing whether she should have recused herself?
I think it's informative, but I don't think it's dispositive. The fact is that it's inherent in the Howard County system that the members of the zoning board are going to be the county council. That's how it's set up. That's in the law.
Isn't that sort of baked in that a member of that particular area would be on the board, and so to be able to not influence but to express the interests of that particular community?
You wouldn't want someone on the zoning board who's out of that district who hadn't weighed in. That would suggest an individual who wasn't engaged in their community, an individual who hasn't been aware of Hickory Ridge and lives in that neighborhood, probably hasn't been all that engaged.
So I think it's a 5-member board. So out of the 5-member board, all of them have villages in their community they're elected from.
They do not. For example, Mr. Youngman, well, actually he does. But I actually know that they all do. I'm not certain that District 1 has a village center in it.
Okay.
But, I mean, they're all, you can't be in Howard
The
County.
individual selected from a particular area in Howard County.
I'm sorry?
They're elected. They're not countywide. They're
Yes, they each have a district. And so the District 1 is essentially, although it's broader than this, Ellicott City.
okay. I understand.
And so they're inherently going to be engaged with their community. They're members of their community.
Okay. So I guess the question would be, questions would always come from a member district. Questions that would go to the Howard County Board would always be from someone's district, because so Yeah, that's the question.
Constituent questions to the county council are always going to hit someone who happens to also be on the zoning board.
That's
Not because
what-
these
that's the
particular
question.
council members decided to put themselves on the zoning board, but because the law puts them on the zoning board.
That's the question.
And if I may just make one point in terms of the emails, because I discussed the previous communications, the subsequent communications I would posit are simply pleasant responses and acknowledgments of receipt without engaging in actual substantive discussion with those citizens regarding the facts of this case. The fact that you say, thank you for your email, I can't talk to you until 30 days have passed after the decision and order was issued, reflects the fact that the council member was avoiding ex parte communications.
Thank you.
Thank you.
Is it Mr. Giel?
Giel, Your Honor.
Giel. Yes, sir.
Good morning, and may it please the court. My name is Grant Giel. I'm speaking on behalf of the Appellate Hickory Ridge Community Association in support of the zoning board. It's coordinated by myself and Mr. Moore. I'm focusing my oral argument on res judicata and matters of the actual recusal standards themselves, which Your Honors have already asked Mr. Moore about, but I'm going to go into more detail. As a preamble to my argument, my firm and its practice area means that it has been before this court many times throughout the decades, often in opposition to development. I say this because it raises an important question of what constitutes recusal before an administrative quasi-judicial body. It is no secret, as a simple statistical matter, that developments are often approved by planning and zoning agencies, especially in more developed counties like Prince George's or Howard. There is often an underlying political component involved in such determinations as well. And yet, in all the decades of our practice, we have never once suggested that a quasi-judicial agency must recuse itself because the members had a tendency to support development. It is one thing to call for recusal and seek enforcement of court, but doing so is a serious action and it requires serious support. And in this case, the appellant's presented argument does not have the latter. Fundamentally, the appellant contends that Debbie Young must recuse herself because the appellant didn't get its way and for once a development was rejected. And they could come back and present a new development proposal, but instead they came here. Importantly, even if Deb Young had recused herself, the board still would not have approved the underlying development because it would have still been a 2-2 tie, which under the Howard County law results in denial. The deciding rationale presented by the zoning board's decision was, as stated by Mr. Moore, presented by board member David Youngman, no relation to Deb Young. Before I get into whether the appellant has satisfied the legal parameters to ask for her recusal, I'm going to summarize the facts that I believe Your Honor has already presented to Mr. O, that Deb Young, before becoming a county council member and consequently a zoning board member, participated in a hearing for development in an area she had lived in for many years. Her testimony was in substantial part a brief summary of what others had already said in that hearing. She thereafter ran for council and was elected in November of 2018. 9 months after she took the zoning board position, appellant's counsel moved to recuse her. They asked her whether or not she would be impartial, and they didn't like her answer that she would, and then moved to recuse her because she had repeated a question, apparently, from her prior testimony. It didn't like the questions, and therefore suggested that because she had asked them, she was biased against them and could not possibly rule in an objective manner. Setting aside the matter of whether or not this is a timely opposition, which we do not believe it is, the fact is that the zoning board considered and denied that motion as a whole, not just Deb Young saying, I won't do it, and then we went along. The whole 5-member board heard the motion and they denied it. At this time, the only supporting evidence was that she had testified 3 years ago on a matter that was already in the evidentiary record before she was a council member. Subsequently, the appellant renewed this line of argument before the court, arguing that she had also had ex parte communications and that she had moved to introduce a person who she thought should be an expert witness, and then that motion was denied. First and foremost, that motion was denied. She just moved for it. It was a one-sentence request. Can this person be an expert witness? Other people said no. They went along. These ex parte communications in question, as stated by David Moore, I apologize, stated by David Moore, were thank you emails. They were thank you for your email. I will respond to you substantively after the matter is fully concluded. Most of those emails were after the board had already voted on the decision. And then it was that interim period of time between the oral vote and the written vote, which, had it changed from the oral vote, would have been a substantially serious matter compared to voting, hearing what the vote was, and then immortalizing it in writing. To apply that to the actual law of recusal now, not only does the appellant need to satisfy a, quote, heavy burden to overcome the presumption of impartiality, see Karnikas versus Cartwright, but that the way to prove this bias is that to demonstrate extrajudicial knowledge that the decision maker could not have derived from the evidentiary record, see Jefferson L. versus State, prove that that knowledge was actually relevant and influential upon the decision at hand, and that the decision maker had a closed mind, see Kaleo. Beyond this analysis are established guidelines for judicial recusal, Chapter 18 of the Maryland Rules. 4 of these sub-rules are self-evidently not applicable to Deb Young. Only one, 18-102.11a1, applies to her, which essentially reiterates the case law, and I think answers this court's prior question by stating that personal bias or personal knowledge concerning a party can invite a recusal. Basically saying what the case law had said itself, that you need some sort of bias concerning a matter that is outside of the evidentiary record, and that bias is affecting you in some way that prevents you from being able to rule objectively in a case. Deb Young's knowledge of the Hickory Ridge development is not by itself grounds for recusal. See Regan versus State Board of Chiropractic Examiners. And as a simple matter, as stated by Mr. Moore, she is a member of the council. Every member of the council is going to represent some portion of Howard County, and there's going to be some impact for one of those members for anything being considered. In this case, her lot was up. It was her district that was had a development being considered. And had this been in a different district, presumably the argument would have been for a different board member to have to recuse themselves, because she wouldn't have been the one involved in the prior proceedings.
Counsel, if I could turn you to the Surratt case for a second. I mean, that's a case where the potential for bias was known way earlier than at the end of the case when remitter was an issue. I mean, so you could read that case as saying that the potential, even though you may know the potential for bias, you don't have to bring it up right away. I mean, how do you distinguish that case if the point of the recusal here is bias as opposed to ex parte communications later?
I ask for clarity, Your Honor. Are you asking this in regards to timeliness of a request to recuse or the substance? Okay. For timeliness, I feel like if the judges are convinced that the appellant properly brought it at the time that they were able to, they still wouldn't win. I think that the fact of the matter is that she was involved for years. The appellant knew she was involved. The appellant knew for a long time that she was going to be involved on the zoning board. But even if it were true that they had brought forward their objection at the right time, that they had filed a motion at the right time, what they were still moving for was that a woman who had testified briefly that said something to the effect of, myself and other members of the community have issues about traffic. That is in no way a heavy burden of proof, satisfying a heavy burden of proof. For something involving a decision about overwhelming use in the community center. The actual decision and the matter that the board turned on and voted 3-2 in favor of wasn't even implicated by her question. And really, to construct an analogy here, if Deb Young had 3 years earlier suggested that Hickory Ridge and its developers were actually aliens, and that she was opposing her development because they were going to construct a mothership, and she was scared of an alien invasion. And then later on, in a 5-person panel, they say it overwhelms the uses, but her secret thought was that it was actually an alien mothership that was going to invade Howard County. Well, that wouldn't have any impact whatsoever. That wasn't the decision. She didn't rule, oh, we're denying it because of aliens. They ruled that they were denying it because the applicant failed to prove to them that they would not overwhelm the development. So even if this were timely, I don't believe that they get anywhere close to satisfying this burden of proof, either with her prior testimony or with the subsequent ex parte communications. And for the remaining minute, I'm going to briefly address the res judicata matter. As also suggested by court questioning earlier. The two cited developments in appellant's case are in different areas of Howard County and concern different parties, concern different facts, concern different adjudicative procedures in terms of like how they reviewed different documents, they reviewed different testimony. None of the elements of res judicata, even if we assume the res judicata applies to administrative agency, or the quasi-res judicata, that one could infer as being binding in certain matters before an administrative agency, none of that's here. You know, even if the appellant had 2 out of 3, if they had the same parties and the same facts but not the same area, maybe. Even if they only had the same facts, maybe. But they don't have the same facts. They don't have the same party. They don't have anything related to this other than the fact that there were 2 prior developments with a superficially similar quality to this one that were decided on different grounds. And then they say that this development must be approved because those ones were. I don't think that is proper in this case and would undermine the land use apparatus of the state if this court were to invite it. And with my time up, does the court have any further questions for me?
Thank you.
Thank you.
Mr. Hurwitz? Good morning, sir.
Morning, Your Honor. Morning again. May it please the court. I'm Joel Hurwitz, pro se. I'm seeking to enforce the rights of the residents of Howard County under Section 202G of the Howard County Charter. Thank the court for this opportunity. The parties do not acknowledge that this case should not end with a quasi-judicial zoning board approval, but with legislative acts by the county council. In 1994, the people of Howard County successfully petitioned a referendum, and the majority of voters approved at the polls a charter amendment clarifying that certain acts related to land use taken by the county must be passed by original bill and therefore are subject to the people's right to referendum. See Charter Section 202G, editor's note. That amendment was codified in Section 202G of the Charter, which reads, any amendment, restatement, or revision of the Howard County General Plan, the Howard County zoning regulations, or the Howard County zoning maps, other than a reclassification map amendment established under the change mistake principle set up by the Maryland Court of Appeals, is declared to be a legislative act, must be passed only by the Howard County Council by original bill in accordance with the legislative procedure set forth in Section 209 of the Howard County Charter. Such an act shall be subject to executive veto and may be petitioned to referendum by the people of Howard County pursuant to Section 211 of the Charter. These are not my words or my interpretation. That was acknowledgement of the court of the referendum in 2013 in Kendall versus Howard County. Contrary to what I find the untruthful statements on page 13 of the appellant's reply brief, this matter is preserved on appeal as stated on page 6 of my brief. Council chose repeatedly not to litigate these matters when I made a motion before the zoning board, which is at page 2097 at SEC, the record, and was incorporated by reference to the circuit court in the memorandum at pages 3852 to 3868 of the record, which included a finding aid of the exhibits in the zoning board incorporated to the circuit court. In fact, in oral argument, appellant made the same ridiculous argument that I somehow should have brought my own judicial review, challenging the application of the charter for matter that was denied. And moreover, counsel is well aware that I would not satisfy standing to bring judicial review. But this was the very reason for the charter amendment in the first place, to give the people the right to challenge if they didn't have standing. Yet even if these issues had not been raised below, they were in response to appellant's argued distinction between legislative and quasi-judicial actions. Appellant chose not to reply that the commissioners in 1965 found that the PDP for Columbia was a general plan for the area. In fact, appellant admitted multiple times in its closing memorandum to the zoning board, including a large heading for a section titled, "The PDP constitutes a general land use plan for the area covered thereby, designed to meet the objectives set forth in these regulations." Their words, not mine. Appellant chose not to refute that the voters partially took back one of the hats of the zoning board as discussed by the court in Turf Valley. Appellant chose not to comment on the legislative procedures that the court acquiesced to in the city of Westminster, where they had a quasi-judicial hearing, denied many hearings, denied the action, and then ratified the denial by a legislative act. Appellant chose not to comment on the quasi-judicial and legislative procedures in Frederick County set forth in my appendix that would probably satisfy all the requirements of Section 202G of the Howard County Charter. Also, if this court does remand, appellate and the other parties have not explained how the boundaries of the village center should be established if without Ms. Young on the zoning board, because they only comment on the overwhelm issue that they've asked you to remand for. The zoning board regulations require that the zoning board establish boundaries of the village center if approval is made. If it wasn't approved, they still could have, but they did not. I argue in my brief that that is a map amendment under Section 202G would require a legislative act, which Ms. Young would, of course, be allowed to participate in. The parties are silent on that, and I hope the court, if to get there, will give some guidance to that. That, I believe, is a map amendment because it establishes somewhat of a development district under subsection K of the zoning regulations for certain steps that would have to be required by any subsequent parties for any subsequent minor redevelopment of the village center once the boundaries are established. And I appreciate your time.
Thank you very much, sir.
Your Honors, again, I want to first of all actually talk about Ms. Young's testimony to the planning board. It wasn't that she just merely adopted or she didn't make a general policy statement. She talked about this specific proposal. She said, give serious consideration to the recommendations of the Hickory Ridge Village Board, the community response statement, which she helped prepare. They also said that the ex parte communications were after the fact. I turn you to Ms. Volsey, who contacted Ms. Young during the case. She said, I lived at wall-to-wall lake, did not enjoy experience, shoddy construction, illegal drugs, dog pee in the walls, more than adequate rental units in 21044.
If I could stop you for a second.
Sorry, Your Honor?
I could stop you for a second.
Yes, sir.
So under the Code of Judicial Conduct, bias and ex parte communication are two separate bases
Yes, Your Honor.
for recusal. Which one are you talking about?
Both, Your Honor. We believe the confluence of every action, including her extrajudicial knowledge about this case. She never said, I'm against village centers. That's okay. If she did that, we wouldn't complain. She said, I'm against this proposal at the planning board, and then showed up. Your Honor, the statement that
So
these
if I could stop you. It seems to me from what you're saying that the issue of bias was apparent, if at all, from back in January of 2018, and the ex parte communications was later.
Yes, Your Honor.
So why not a motion to recuse at the beginning for bias, which is something that is not curable through a disclosure?
We did, Your Honor.
Why not?
We did file that.
Back in January of 2018?
We filed it the month afterwards. Remember, we had some trepidation because of the passage of time. At the very next hearing, we filed a written motion. This was not trying to weaponize the process. There were 18 hearings after we made the motion to recuse, after she denied it. We went through and we lived with council members who said, this is not an apartment area. Your Honor, that's a policy statement. The law that was passed in 2009 allows apartments in these village centers. They all have the same zoning. The uniformity principle under zoning would require that they be treated the same. These administrative board members don't have to say, you know, I think there should be an exception for Hickory Ridge. The time for that exception would have been at the time of the legislation in 2009. The testimony from the residents was, well, this is a single-family detached neighborhood. They should have asked for an exemption during the legislation. The application of the legislation is done by administrative body. And the council member, I have no problem with the council member being the district person. What they can't do is say, I participated in this process. I'm going to go in public, speak on this. I'm going to run for the council, and I'm going to sit on this zoning board and make the decision. If we don't have a reasonable belief that we are deprived of impartiality, I don't know what is. The reason why the county went this way, because they misread the Turf Valley case. They thought that Turf Valley was for quasi-judicial, and that is incorrect. Kenwood Gardens is very clear. It is a reasonable standard of impartiality, and we fit that. That erroneous conclusion of law bled into the substantive aspect. Yes, Your Honor.
Your time is up. Thank you very much. Case is submitted. Thank you, counsel.